Hello, everyone, and welcome to Thursday Talks with Chug. Each week, we cover pressing topics that matter to you and your business. I'm Arianna Gonzalez from Chug, attorneys and CPAs tuning in from our San Diego office. Please join me in welcoming partner and attorney Min Kim from our Edison, New Jersey office. Hi there, Min, and welcome.
Hi, Ariana. Thank you for having me back.
Thank you so much for being here. So for today's topic, we're going to be answering all your pressing questions on e-Verify. Just a quick disclaimer before we get started, this conversation is for informational purposes only. It does not create an attorney-client relationship, so if you have questions, please comment them below or email us at info@chug.com. So let's get right into it, Min. We said we're going to talk about e-Verify today. I know that for these talks, we're going to talk about the newly launched e-Verify Plus, but just a couple of days ago, there was a rather large announcement made by USCIS, and I was hoping to at least touch on it before we pivot to e-Verify. So, is it really true, Min? Will USCIS really run a second lottery for this year's H-1B cap registration selections?
Yeah, that's correct, Ariana. On Tuesday, USCIS announced that the agency received enough H-1B cap petitions to fill the 20,000 U.S. Masters cap exemption, but that they were still short of the 65,000 number for regular cap cases. What this means is that USCIS will conduct a second round of lottery selections from the batch of H-1B cap online registrations that were filed in March of 2024. And from this newly selected pool, H-1B employers can then petition for H-1B cap for their selected beneficiaries.
Okay, but I don't think I'm mistaken when I say that at least in recent years, this trend of USCIS conducting a second lottery in the middle of the year has not been all that uncommon.
That's correct. Since the start of this H-1B cap online registration system in 2020, USCIS has always had to run multiple rounds of lottery selections. Most times it's been just one additional round to ensure that all 85,000 cap numbers are accounted for. But there's even been a year where three separate rounds were conducted. So this news that another selection round must be done this year isn't all that surprising when compared to this recent trend.
I find that to be really curious. So why do you think that's the case? That USCIS has fallen into the habit of needing to conduct these multiple rounds of lottery selections. Is this the new normal for us? I mean, generally speaking, I've always thought that H-1B cap numbers were in such high demand, and employers and beneficiaries are basically falling over themselves to get one. But what do you think that moving forward in future years, both employers and employees can reasonably expect that just because a beneficiary's online registration isn't selected in the first go around, that there's still a fair chance that another round of selections will occur later in the year?
I think that's a reasonable interpretation, at least going by the last few years worth of data. Don't get me wrong, H-1B CAD numbers are still in incredible demand. USCIS noted that for this most recent H-1B cap lottery earlier this year, the agency actually received over 470,000 online registrations. And from that 470,000 total, USCIS ended up selecting a little over 120,000 in the March 2024 lottery. It's just that not enough actual I-129 H-1B cap petitions were filed by employers.
Okay, so now since we know the underlying reason as to why a second lottery is to be done, what must H-1B employers or the beneficiaries whom they sponsor do to ensure that they're included in the second lottery?
Well, that's the thing. Nothing really needs to be done. The employer should regularly check their email as notification of a registration selection should be automatically sent to the email that's on file when the online registration was first submitted. Employers and or their attorneys can also log on to their respective myUSCIS account to check if there are any new updates or changes to the batch of registrations that were unselected the first time around. But there really is no next action step that an H-1B employer or foreign national beneficiary must do. USCIS is simply going to go back to the original online registrations that were received in March, and deciding to randomly select another set number and notify those selections that they are now eligible to file their I-129 forms.
Okay, that makes sense. Even though I'm sure that many beneficiaries and employers are quite anxious and eager to do something, which is understandable given how important this news is to many of our audience, it's good to know that the second lottery will just automatically be done without any need to do something. Do you have any final words of advice or caution pertaining to the H-1B cap that you want to provide before we move on?
Just some final things, I suppose. One, as mentioned earlier, USCIS confirmed that it received enough I-129 petition filings for cases involving the U.S. master's cap exemption. However, this doesn't mean that just because a beneficiary's online registration was originally submitted as part of this U.S. master's exemption group, that the registration won't be now included in the second lottery. It will be, because if a foreign national qualified for the U.S. Masters Cap exemption, but they were not selected in that first round of lottery selections earlier the year, either in the master selection or the regular cap, that beneficiary's registration will still be considered for selection in the second lottery to come. And also just a word of caution for those who happen to be in F1 student status and relying on their OPT to work. Cap gap is tricky, and I know that this is not the topic for today, but the timing of the I-129 form with USCIS will either trigger cap gap to allow the beneficiary to stay in the U.S. lawfully and perhaps even grant them continued work authorization, or it might not apply at all if the H-1B cap petition is filed too late. So those F1 students who are relying on cap gap, I would advise those eligible students to work with a trusted immigration attorney or in-house counsel so that you understand these unique cap gap rules and what might apply and won't apply given this second round of lottery selections.
Sound advice there, Min. And something I can reemphasize for our audience as well in reminding our viewers that these Thursday talks are intended for informational purposes only. They do not constitute any form of legal advice. So if you do want to learn more about these issues, you should really speak with your company's in-house legal or HR team so that you can receive advice that is accurate and specific to your individual situation. Also, if you do want to read up on this topic, you can subscribe to receive our law firm's immigration client alerts. Yesterday, we had an alert sent out already regarding USCIS's plans for a second lottery. So you can go to our website, www.chug.com. There is an option on the top right corner to sign up for our newsletter. You can pick immigration, legal, tax, up to you. So go ahead and check that out. Okay, on to today's topic, E-Verify and E-Verify Plus. Min, please tell us what we need to know about this.
Well, let's start with the foundation and the basics, and we can kind of build from there. Just generally speaking, E-Verify, it's a free online-based system that is maintained by Homeland Security, which employers may use to confirm the employment eligibility of all newly hired employees, both U.S. citizens and non-citizens. So, given that, what are some takeaways from all of that? Well, one, it's intended for employers. Although there is a related function called myE-Verify, which we'll talk about in a short bit, which is intended to be used by workers and job seekers. Two, it's free. Three, it's voluntary, with some caveats and exceptions that might apply. And four, it's intended to be used for all newly hired employees. As an employer, you should not be running E-Verify checks on your existing employees, and you cannot choose to run an E-Verify query for some new hires and not others. That's strictly forbidden and will result in a finding of discriminatory hiring and retaining practices. How does E-Verify work? It basically compares the employee's identifying information, things like their name, their social security number, against government databases at the Social Security Administration and Department of Homeland Security, in verifying that the identifying information matches to prove that the employee is indeed work authorized and is who he claims himself to be. And the audience should know that the far majority of E-Verify checks, they result in the system returning back to say that the worker is actually indeed employment authorized. However, at times, if there is a discrepancy between the data derived from the completed I-9 form, which is entered into E-Verify and cross-checked against DHS and Social Security databases, then one can expect a tentative non-confirmation or TNC to be issued. And then specific remedial steps must be followed by both the employer and the employee in order to resolve these issues.
Okay, so if I understood you correctly, in completing E-Verify, the employee's completed I-9 form is involved. I thought the I-9 form was intended to check on the eligibility of one's ability to work, but you're saying that E-Verify does that. So can employers just use this free online E-Verify system and not complete I-9 forms for their new hires?
No. E-Verify, it's not meant to replace an employer's I-9 obligations. Those are fixed. E-Verify is simply meant to add an additional layer of checks on top of the traditional I-9 process. Once again, in most cases, it's completely voluntary unless the employer falls within one of the exceptions where E-Verify happens to be required. One such example when E-Verify would be required is, let's say if the company has entered into a contract with the federal government that rises to a certain monetary threshold as stipulated by the executed contract, or if the business happens to operate within a state that either requires E-Verify for all or certain employers. As of now, I believe 9 states in the US require E-Verify for either all or most of the companies within those states' borders. But I should also mention that if an employer wants to employ F1 students who qualify for an extension of their OPT as a result of a STEM degree, then that employer must also use E-Verify at the intended work location for the STEM OPT employee.
Okay, so E-Verify is voluntary until it's not, and your business falls into one of these exceptions and then it becomes required. But in general, after an E-Verify check is run, it appears that there are 2 end results. E-Verify confirming that the worker is employment eligible or a tentative non-confirmation being issued, and it seems that most cases show that the worker is employment eligible. How does this E-Verify check, how long does this E-Verify check take typically, and what happens next when E-Verify shows either employment eligibility or a TNC?
Well, I suppose in my opinion, one of the better features of E-Verify is that it's really quick. An employer runs an E-Verify check, and usually within seconds, the results will soon follow. If the result shows that the employee is employment authorized, the employer should attach the E-Verify authorization document to that employee's Form I-9 or record the system-generated verification number on the I-9 form. If a tentative non-confirmation or TNC results, then the employer must immediately notify the employee and provide him or her with written instructions so that the employee can look to cure this mismatch, either with the Social Security Administration or Department of Homeland Security. Or, the employee can choose to do nothing at all.
Wait, nothing at all? An employee can just decide to do that?
Yes, if an employee chooses to not contest the TNC result, then after 10 or so federal government working days, the TNC becomes a final non-confirmation, and the employer must terminate the employment relationship since it hasn't been shown that the employee is lawfully employment authorized. And at that time, the employer will also close the E-Verify case.
Okay, but what happens if an employee chooses to contest the TNC? I would imagine that most employees would do so. So what does a roadmap for employees and employers look like for them to follow?
Well, the first thing that the employer must keep in mind is that no adverse action can be taken against an employee who happens to receive a tentative non-confirmation mismatch. The employer it cannot terminate, suspend, or take any such adverse employment action against that worker because a TNC, if the employee happens to choose to contest the mismatch response, the employee must remain employed, as the employee must be given every opportunity to clear the mismatch with either the Social Security Administration or Homeland Security. In total, 10 federal government working days is the time that an employer has to resolve the TNC mismatch issue. And this 10-day period starts from when E-Verify first produced the mismatch result. That is why it's essential for the employer to immediately notify the concerned employee about the TNC, because if the employer delays even a little bit, it can be perceived as unfairly removing the ability of the worker to resolve the mismatch with the concerned government agency. And with such a delay on the part of the employer, does that expose the employer to penalties? Perhaps, depending on how egregious we're talking about for these delays.
Wow, those takeaways are really good to know. And hopefully, our employer audience members who participate in E-Verify will know that they should not delay in contacting the employee in the event of a TNC mismatch. And while all of this is occurring, the employee must remain employed, and no such adverse employment action in response to a TNC can result. So, what are some other things employers should keep in mind?
Well, there are two notices that are relevant, pertaining to this. One, it's called a referral action confirmation letter, which on its face provides the date by which contact with the Social Security Administration or Homeland Security must be made. And two, something called a further action notice, which provides instructions to the employee on what to do next. Both notices should be given to the employee promptly as part of notifying her that a TNC resulted. And thereafter, the employee will have 8 federal government working days to contact either the Social Security Administration or DHS in resolving the issue. And if the employee does contest the TNC, that agency involved, either Social Security or Homeland Security, has 8 federal government working days thereafter to address that issue.
But Min, what about those employees who might not have a social security number? I don't think it's the case where one must have a social security number in order to be eligible to work. So if a person does not have a social, how can E-Verify check be run in cross-checking the employee's data with the Social Security Administration's database?
That's a fair point, Ariana, and a good observation from your end. You're right. Legally speaking, an individual does not need to have a social security number in order to work. But regardless, E-Verify requires entry of one's social in order to run the case. And this is one example, I suppose, where E-Verify, it sort of deviates from typical I-9 rules. Remember, the data that is used to complete the form I-9 is then used by the employer to run an E-Verify check. So in terms of sequence and what happens when, an E-Verify query can only be done after a job offer is made to a new hire candidate, and that candidate then accepts the job offer and after Form I-9 is completed. However, the I-9 form does not require entry of a new hire social security number, as simply NA can be written instead on the form. But since E-Verify cannot be used for employees who don't yet have a social security number, in these instances, the E-Verify check should be postponed until a social is received by that specific worker. But here, the audience should keep in mind as well that this doesn't mean that the employee should not be onboarded, as Form I-9 can still be timely completed. It's just that without the social security number, and the employment can then start with this worker. What simply needs to happen is that the E-Verify query needs to be put on hold until the social security number is received, and then the employer can then go back and run the E-Verify check while also asking the employee to enter her SSN now in section 1 of Form I-9 and initialing and dating with today's date to denote an update on the I-9 form. What should not happen is for the employer to refuse the employee from starting to work just because an E-Verify check cannot be done, given that there is no social security number at hand. This can be interpreted as unlawful discriminatory practices on the part of the employer, as the employer essentially then is using E-Verify as a screening tool as part of its hiring and onboarding processes, which is strictly forbidden and will result in penalties being assessed.
It's really interesting to hear that, as you said before, E-Verify seeks to supplement what Form I-9 originally and still seeks to achieve in terms of verifying the employment eligibility of a new hire. So there is a lot of overlap between the two, but there are also some very distinct differences, like the example of the Social Security number. I-9 does not require one, whereas E-Verify does, and the workaround that employers must go through in order to accommodate these slight variations and contradictions. I mean, ultimately, as you said, the fact that an individual does not have a social security number and thus an E-Verify check cannot be run at that moment should not prevent the worker from starting. Hopefully, our E-Verify employers understand that in order to limit their exposure to ability. Any other differences between the two that we should know about?
Yes, another example that I can give is how E-Verify requires that a list B document that proves identity, it must contain a photo. Whereas completing Form I-9, there is no such photo ID requirement. Another example related to that is that E-Verify has a tool, it's called the photo matching tool, which enables an employee's photo to be matched with the photo that USCIS or the State Department might have on file for that particular employee. This photo matching tool, usually it comes into play when a List A document, such as an EAD card or US permanent resident card or US passport is used to prove identity and employment eligibility. And it sort of happens automatically once an E-Verify query is run using such a qualified document. And when a qualified List A document is used, that document which was used to verify employment eligibility and identity, it then needs to be saved as part of the worker's I-9 file, which is sort of in stark contrast to the document retention rules that apply for Form I-9, which typically do not require the employee's passport or EAD to be retained.
Okay, let's wrap up this part of our E-Verify discussion with perhaps some pros and cons for employers out there who are not yet E-Verify employers but are considering enrolling in the program. Also, if you can, Min, please provide some quick hitting takeaway points for our audience before we pivot to talking about how job seekers and workers can use myE-Verify.
Yeah, absolutely. E-Verify is definitely not perfect. And depending on the company and what industry they operate in and their specific business model, there are reasons for and against enrolling in E-Verify. But let's start with the benefits first. Perhaps the biggest reason to choose to enroll is that it opens the marketplace in hiring and continuing to employ F1 STEM OPT workers. As I mentioned earlier, and as most of the audience would already know, if an F1 student graduated with a qualifying STEM degree, science, technology, engineering, or math, they might be eligible to further extend their OPT EAD employment by another 24 months from the initial grant of 12 months of OPT. However, in order to qualify for this 24-month STEM extension, the employer must be registered, and in good standing with E-Verify. If the employer is not an E-Verify employer, then it wouldn't matter that the F1 student earned a STEM degree, as a STEM extension would simply not apply, because it only applies if the employer is registered and in good standing as an E-Verify company. Another benefit that I can mention in participating in E-Verify is that depending on the state your company is in, a specific state's rules might grant a sort of like a safe harbor to you as an employer from violating your own state's employment laws. Thus, enrollment in E-Verify can potentially serve as a shield against certain claims of knowingly hiring unauthorized workers.
Okay, so those are the reasons to enroll in E-Verify, but what about the risks and reasons to decide against it?
The cons are, are just as compelling depending on the nature of the employer's business. As part of the memorandum of understanding that you as the employer sign with the federal government upon registering for E-Verify, you must agree as an employer to allow Department of Homeland Security and Social Security Administration officials to visit your work sites to review E-Verify records and other employment records associated with E-Verify. Moreover, and this is probably the biggest issue, E-Verify is not error-proof. It's known to make mistakes, and those mistakes can be entirely innocuous and unintentional. Perhaps, let's say we have a misspelled name on a government document, or something as commonplace as a name change. But if the result is a TNC, then those protocols that the employer agreed to in enrolling in the program must be followed. But in practice, the Department of Homeland Security and the Social Security Administration agencies which work with the employee to cure these mismatches, they're often delayed and they often misunderstand what is being asked of them. So any form of resolution in looking to cure a mismatch is rather hard to come by, especially within the 8 federal working day timeframe that E-Verify requires. And before, you also asked for some, quick hitting takeaways for our audience. Some things to keep in mind are, one, unless a qualifying federal contract is involved, the employer cannot use E-Verify retroactively in checking employees who are hired before the employer first enrolled in E-Verify. Everyone needs to keep in mind that only new hires can have an E-Verify check be run. If an attempt is made to run an E-Verify query of an existing employee, that will result in severe penalties being assessed. A second takeaway point is that an employer is always free to de-enroll in E-Verify at any time, so long as the required notice obligations are complied with. And three, just because a company is an E-Verify employer, it does not grant them immunity from any kind of worksite enforcement or investigation. At least at the federal level, there is no safe harbor or shield to protect the company from any sort of enforcement proceedings.
Thank you so much, Min, for sharing those insights. We're going to stay in the E-Verify universe, but let's talk about myE-Verify and the upcoming newly launched E-Verify Plus. What should we know about these tools?
Well, the distinction is that E-Verify, it's for employers who, once they're enrolled in the E-Verify program, they must check the employment eligibility of all new hires at the hiring site. Whereas myE-Verify is for workers and for job seekers to help such individuals understand and manage their employment eligibility verification and to help them protect their identity. In order to access myE-Verify self-help tools, a user needs to create an online USCIS account, and with the available tools at their disposal, the worker can see when and where their private information was used by a hiring employer in creating an E-Verify case check. This case history track that's available on the portal, it goes back 10 years of data for the worker. So the worker will see each hit when a TNC mismatch was issued, as well as all the times when he was deemed to be employment authorized after an E-Verify query. Also, one of the newer features available on myE-Verify is the ability to upload documentation to resolve certain TNC mismatches. Now the audience needs to keep in mind that this upload feature is not intended to replace the need to still contact Homeland Security for in seeking to resolve the TNC. But if the upload feature is used properly, it can certainly expedite the resolution, so a final non-confirmation can be avoided. And finally, another self-help remedial option available on myE-Verify is the self-check feature, which allows a worker or job seeker to affirmatively check their employment eligibility on their own to ensure that the same government databases at Homeland Security and Social Security Administration, which the employers use in running an E-Verify case, those databases properly reflect the worker's ability to work. Thus, it sort of provides a peace of mind to a job seeker, knowing in confidence that any such future issues will be avoided.
Those are really interesting tools available to workers and job seekers. Notwithstanding the added protections against identity theft, to think that a job seeker can use the self-check feature to receive advance notice whether their data results in a mismatch or not, it really allows them to get a head start in making sure that all the corrections are made at whatever government agency so that when an e-verify query is made by an employer, the work authorization reads as correct. It seems like this feature should be used more often by workers and job seekers.
I agree. It's definitely not error free, and hiring employers cannot force this self check feature on its job applicants or hired employees as a form of as a form of a pre screening tool. But to your point, if used the proper way, it can definitely help in expediting a worker's employment eligibility.
All right, we're coming to a close to the end of our time, so let's quickly pivot to E-Verify Plus. What is E-Verify Plus and is it available now to be publicly used?
Well, starting with your second question, the answer to that is no, not yet. A pilot program was launched this past spring, and certain employers were invited to partake in the new program so that Homeland Security can gather feedback and make any modifications in improving the user experience. But since this test run of the pilot program, there hasn't been much news on E-Verify Plus. But what we do know is that it seeks to make things a bit more streamlined and efficient, and ultimately wants to achieve the goal of having the new hire worker have a bit more control on how the E-Verify process is run, as well as a bit more control over their own personal information. Some of the new features introduced by E-Verify Plus are better integration of Form I-9 into E-Verify by introducing an employee-facing portal which tasks the employee to enter her private data. Thus, it creates a more efficient method in transposing the data from the completed I-9 form to the E-Verify Plus case. If this change is implemented as intended, for me, what immediately comes to mind is that such an automation will definitely help to reduce human data entry errors, which in and themselves might result in a TNC mismatch. Another feature of E-Verify Plus is that in the event of a TNC mismatch, the further action notice is delivered directly to the employee, and thus employers no longer need to print the actual notice and make it a point to give it to the employee with the accompanying instructions. Currently, in its present day form, E-Verify places that burden and responsibility on the employer to immediately deliver such a further action notice to the employee, so the employee can decide what to do in seeking to cure the TNC or to just kind of let it go. E-Verify Plus removes this step and the potential liability that might result from a delay on the part of the employer, and shifts that burden entirely to the employee from the start. It's a sensible and rather elegant solution, in my opinion. It doesn't depart from what the current iteration of E-Verify seeks to achieve, and it seeks to just improve upon by eliminating an unnecessary step and delivering notice of what needs to happen next for the employee. Such efficiency is rather critical, especially when time is of the essence, as every day matters in seeking to resolve a mismatch either received from Social Security Administration or DHS.
I couldn't have said it better myself, Min. Every day does matter and could mean the difference between a TNC mismatch being resolved to read as employment eligible or a final non-confirmation which results in the worker being terminated. We're talking about high stakes here, and I'm glad to hear that Homeland Security is looking to improve the user experience in promoting efficiency.
Yeah, absolutely. Another feature of E-Verify Plus is that the system promises that in most cases, if a worker checks out as verified and employment eligible, that same worker will be able to carry that verified status with them to a subsequent employer who also is enrolled in E-Verify Plus.
Oh, wow, really? So an e-verify check would not need to be done by that second employer since e-verify plus confirmed the employment eligibility previously of a new hire?
In theory, from the little information that's out there, that appears to be what the program is promising. And with that comes, the natural result of a Form I-9 not needing to be completed over and over again by the employee, since the first I-9 can then follow the employer. I'm sorry, can follow the employee to the second employer and so on. But in reality, until E-Verify Plus is officially released to the entire public, we can't say for certain. But the premise of increasing efficiency and eliminating waste and duplicate steps, it definitely seems to be what Department of Homeland Security is trying to go for, and that can only improve the user experience for E-Verify.
I agree, and I'm eager to see what the final e-verify plus product will look like. Do we have an ETA on when will be released, or do we not know anything about that?
Not yet. Homeland Security, they're quoted to say later this year, but beyond that, not much of an ETA.
Okay, and what about where employers can find the new e-verify plus? Is it on the same interface and webpage as e-verify, or until it's officially released, its whereabouts are still unknown?
Well, USCIS says that E-Verify Plus will be located on the same resource page as E-Verify. Once again, E-Verify Plus is not meant to supplant E-Verify. It's an optional, free-to-use supplemental tool that employers can elect to use to better improve their user experience when they open an E-Verify case to run a check for a new hire. It's not meant to replace the current version of E-Verify.
Got it. Good to know. I guess it's always good to have options. Employers who are hesitant to learn something new and are familiar with E-Verify can continue to use it, whereas other employers who are a bit more adventurous and want to test the waters in trying some added features in E-Verify Plus are free to do so as well. Well, honestly, Min, we are over time, but this was a great topic, so I appreciate you sharing all of your insights. That is all we have time for today. So thank you so much, Min, for your insights. Thank you everyone for joining us today. To stay up to date, please subscribe and follow us on Facebook, LinkedIn, and YouTube. If you have questions or suggestions, email us at info@tube.com and make sure to join us back here next week for more pressing topics that truly matter to you and your business. Until next time, stay safe and take care, everyone. Thank you for joining us. Thank you so much, Min. We really appreciate you.
Thank you.